we can always do. It looks like I won't go more time than you. I can. We can say, well, yeah, I can try some concepts, or we can do it after when we talk. You know, another way. I don't think there's any music, unintended sounds, effects in this one. I just remember what you told me when I gave you that one PowerPoint. I had this.
It's funny, right? Students
We'll just switch places again. Yeah. Just remind me.
Good morning, everyone. My name is Mark Bernstein. I'm the Deputy Director here at the Duke Law Library, and so I thought it'd be nice, I'm not going to speak, but to introduce my colleagues who are put together and presenting the program, two of our reference librarians, Valerie Weis and Michael Hannon. Mike's going to speak first and speak about the technology-related issues of this program, Napster and its progeny, and then Valerie will follow and talk about the legal implications, the copyright law, and that sort of thing. So, with that.
Thank you. Thanks all for coming. As you can see, this is what started it all, basically, Napster, that evil little icon there. Now, there's actually a lot of talk going on right now about what peer-to-peer is, and there's not really an agreed-upon definition at this point. There's a lot of people banding a lot of things around about it. But here are a couple definitions that I found that I think a lot of people would agree on that a peer-to-peer networking thing would have. And one of them says peer-to-peer is a communications model in which each party has the same capabilities and either party can initiate a communication system. So there's a notion of equality between the computers or the peers that are out there. Or another definition, on the internet, peer-to-peer is a type of transient internet network. It allows a group of computer users with the same networking program to connect with each other and directly access files from one another's hard drives. And that's basically when we're talking about music sharing, is what is happening. But there's always this notion of equality between the peers and no central server. So there's going to be a big distinction between client-server type of technology and peer-to-peer. And also some peer-to-peer components will talk about a self-configuring component, that these networks can self-configure themselves, and then that will be important to a peer-to-peer definition. Now, we're going to contrast this with traditional client-server network, which is basically what we're all familiar with, the web, the internet, the net, when we go online. Basically, web users, clients, are connecting to servers in just about any kind of internet activity that we're doing. Going out there to Amazon.com, going to get a file somewhere, clicking on a link, going to Google. You're going through a server at some point, even email clients. Even though you think you're sending it to somebody else, you're really going through a server system. Client requests files and servers provide them. Client requesting information, servers providing it. Clients do not actually interact with the other clients, even in email, again, which is about basically what almost everybody on the planet that's on the internet uses. Even though you think when you hit that send that you're sending it to somebody, it's actually going to a server system first. Even instant messaging, which seem to be more person-to-person, it still has a server component, okay? And then there's a whole DNS system that's underlying everything to resolve IP addresses and IP names. Okay, so here they are. And interestingly, the people that are proponents of peer-to-peer, they on the head left, I have the file server. Resources are controlled by the file server. This is a big deal to peer-to-peer proponents. They do not like this file server. This thing represents old school type of thing. It represents authority. It represents something that might be slow, something that might be down, something that might require you to tell them who you are, might require a password, and even it might even ask for a credit card and actually like to pay for music, and they don't like that. Okay, so proponents do not like the file server system. What they'd like is resources in the peer-to-peer are shared among equals in the peer-to-peer network. And so basically these things can ask each other for information and can provide it. And there's no need for a central server. There's actually a couple different models. 3 I'm going to talk about of peer-to-peer networks. And we'll talk about what I said the first generation would be Napster. Napster was centralized. A great deal of it was actually centralized, even though it fits into the peer-to-peer talk. And actually knowledge about the peers, who was online, what files they had, was actually controlled by a central server or a system of servers. And then Nutella would consider second generation. Early Nutella was a totally decentralized system. The peers do all the communication and they actually hold all the knowledge amongst themselves. There's no centralized presence whatsoever. And the latest, after this, we consider third generation is, we could consider later Nutella type of software and Caza or Caza. I'm going to call it Caza because I don't want to keep correcting myself. Although I think if you're really in the know, it's Caza. Okay, but I'm going to stick with a Caza because I'm more comfortable with that. But I would consider that like a third generation, and it's decentralized, but it also brought in a centralized component back in. With Taza, they call them Supernodes. Newer Nutella will call them ultra peers. Basically, they're like beefed up computers that are still peers, but they're sitting on high bandwidth. They agree to be Supernodes or ultra peers, and they're going to take on some of the centralized function to make it. They'll take on some of the file indexing, and they'll connect the peers, slower peers, in with other Supernodes and help with the searching and stuff. Now, we'll talk about Napster first. I'm going to talk about how Napster worked, because what I'm going to talk about is what I call Napster BC, which is before court, and not Napster AD, which is after the decision, because they're two totally different things. Interestingly enough, Napster BC was not pure peer-to-peer, P2P. It wasn't pure peer-to-peer. And many purists of peer-to-peer will point that out, because Napster had a very large, very dominant server component to it. The server or server farms acted as indexes or directories of music files into the peers. They were also traffic or information managers. Clients actually logged on and off Napster servers, and the servers would update their directories when peers came on and when they went off, and also updating who had files, what they were. So they also controlled search and queries that went to the central server. Okay, so you actually didn't go out and search to another peer. You went to a Napster server. And then what it is a server matched up the server and a potential client that was agreeing to share that type of music. And then after the client and the one that was going to give a file, the one that wanted it agreed, then the server got out of the way. Those two negotiated through HTTP and actually did the file transfer amongst themselves. So really at the end is the only time that you had a true peer-to-peer working with the Napster system. Again, all the peers had to register with the server, but this actually helped with good search performance, comprehensive searching, and quick results. But importantly, physically, the server never actually contained actual music files. It just had the important metadata about who was online and what music their computers contained. So it actually said who was out there, what music was on their hard drives that they were willing to share. Okay, but it was actually sitting out on each individual computer's hard drive what music was going to be shared eventually. Napster was basically limited to MP3 music, and they did have an instant messaging component. Later, peer-to-peer systems have just about anything that can be reduced to a file that can be shared. And here's just the graphic that I got from How Stuff Works, showing the Napster system. Basically, all these will be Napster clients. They've already told the central server, I'm out here, here's what I have. Here's the music that I have on my hard drive. And this particular computer here requests a song, requests it to the central server. It checks what it has, it sees who has it, it makes a match between this computer or what it wants and this computer that actually has it and is agreeing to share it. And at that point, the server gets out of the way, these two negotiate HTTP transactions, and they actually download it between themselves. Now, Nutella grew up to be basically is considered the first true P2P model, at least the first one that actually got out there and became well known. It didn't have any central server system at all. Later ones did, but at the beginning it was totally decentralized peer-to-peer protocol. The peers send searches and requests amongst themselves as equals. It's not limited to MP3s, movies, all kinds, anything that basically that could be a file that you can actually share through the Nutella protocol. Each peer acts as both a server and a client. If it's offering files, it's a server, and if it requests files, it's a client. And so what they kind of be called is a servant. They kind of combine those terms. Nutella's distributed method. Nutella peers send queries for files. They actually broadcast it out to all peers that's within their horizon. Basically, I'm going to go into it in more detail, but they have a horizon that so how far this message is going to go. When the other peers get it, they pass it on. So it actually fans out kind of like ripples in a pond. If you throw a rock out there, it's going to ripple out. And it kind of goes out like that. We'll go into more detail about that in a minute. Now, Nutella messages they set a time to live, which is, if you're familiar with TCP/IP on the internet, it's the same concept. Each packet is given a TTL, usually 4 to 7. When a peer gets a message from another peer, it's going to look at it, and before it passes it on, it's going to see how many, what the time to live is. If there's still enough time to live left, it's going to decrement it by 1, just like a router on the internet, and it'll pass it on. Eventually, it'll die out. Once if another peer gets it and it's already up to the limit for the time to live, it'll drop it, it'll discard that packet, and won't pass it on anymore. It cuts down an infinite loop, stuff just going on and on. Even a 7 hops, though, it could mean that the horizon of one peer would go out to like 10,000 nodes or 10,000 peers out there. So it can get the message out pretty far. The messages are assigned a unique identifier called a UUID, 128-bit. And the peers actually keep like a little informal routing table amongst themselves. And they'll know if they've seen that message before. Because if they get a message that they see the same UUID, they won't pass it on. It's another way of cutting down on some traffic that they don't need to deal with. Actually, Nutella, when we say Nutella, we're talking about a Nutella protocol. There's actually several flavors or software clients that support Nutella. BearShare and LimeWare are probably some of the most well-known that are out there, but there's actually a bunch of these things. Most are open source. And one of the big proponents a while back of peer-to-peer summed up peer-to-peer, the early Nutella model, as called it messages are relayed by a computerized bucket brigade, which forms the Nutella network. Each bucket is a message, and each brigadier is a host. Or you could actually look at it. You've all seen probably pictures of when there's a flood somewhere, happens in the United States, a river flooding, town gets out there and everybody's sandbagging, passing the sandbags to each other. That's kind of like how Nutella works. They just pass it on, each passing that sandbagging on to the next person. And this is another graphic that kind of shows it. So Piers here, he's already told everybody, he sent out messages telling them he's here, and also gotten back messages to see who's in his horizon. But it broadcasts out looking for a certain file. It's actually passed on. It goes to this one passes on to everyone it's attached to. So it's fanning out. Eventually it'll get up to another peer that actually holds that file and is agreeing to share it. And then that person or that computer will pass back the information, enough information, IP address and things to get to this one so they can set up their HTTP contacts and actually download it. Okay, stuff is fanned out going across, and so you can see it can actually get out. That message can be pretty far. In this example, it could be out 67 time to lives or hops get out there to like 8 or 10,000 computers. Now we'll go to the next and last generation of PTP, and this will be Caza and also newer Nutella. And these combine both distributed and Napster-like aspects. They're still distributed, but they use this component called ultra peers and supernodes, which are basically fast computers sitting on high bandwidth, broadband that are willing to be supernodes or ultra peers. The supernodes actually is a hub for searching. The peers will send lists of files they share and queries to the supernode. Supernodes will forward search requests to other supernodes. When the peers are matched, supernode will get out of the way, just like Napster, and then those two peers will negotiate the file transfer between themselves. This is actually how Caza describes right on their website exactly how their supernodes work. And the supernodes also contain lists of some of the files that are available, so it cuts down a lot on searching. They kind of like segregating the network, so to speak, so that peers that are not agreeing to be supernodes, maybe up on dial-up or whatever, will just deal basically with the supernodes, and really the supernodes deal with each other. So they kind of segregate the network, and it scales better that way. It cuts down on excessive searching and querying. There's a lot of peer-to-peer, there's a lot of chatter going on too, just by these peers trying to tell each other who's around and stuff. Now, Caza has basically become probably the most talked about peer-to-peer software right now. It actually became the most downloaded software in history back in May of this year. At that point, it hit over 230 million downloads. It actually beat ICQ, which was the previous record holder. And just for the week of June 9th of this year, it had over 2.5 million downloads. And the next most common was ICQ Lite, which is basically a basic version, and it had just a little over 500,000 during the same week. And June 11th, which a couple days ago was the last statistics I saw, because Caza had, as you can see, over 235 million. In comparison, Napster had perhaps 80 million registered users at its peak, and I say perhaps, that's probably the highest number I've seen. I've seen other numbers of 70 million. It's not exactly clear. It's not clear how many unique users there were. You know, people can sign up for different under aliases and that kind of stuff. Now, there's a couple of technical aspects of these newer type of third generation P2P things. They have a thing called multi-source downloading. If a file exists on more than one client, it can be downloaded in pieces from each. So different parts of the same file can be downloaded at the same time from different clients. And this will speed up downloading, and then they're actually rearranged on the computer as a completed file. Swarming is also this, where similar to multi-source, will actually gather various sources together with the same file and group them together, and then they'll go into a multi-source downloading function. There's also better capabilities of where if something gets cut off, your transaction gets cut off, there'll be things that can memorize it, and you can complete the transaction later. So this stuff's pretty intelligent now. Now there's some new twists of these third generation peer-to-peer programs. There's the thing that network administrators do called, falls under the activity of packet shaping. Basically what they do is network administrators have tools. They can go out and look at this stuff. They can see that peer-to-peer is eating up a lot of the bandwidth, and they can say, you're not going to get that much bandwidth for this. We're going to segregate that area. We're going to push you down and get lower priority. We're going to give it to our other applications that we need at like the university or something, or a corporation, that are going to get higher priority. So that packet shaping, in order to get around that, new P2P programs have engaged in one thing called dynamic port hopping. With a P2P application, it'll no longer use a static port. Like previously, Nutella used to use like ports 6346 and 6347 among other, and Caza used 1214. And actually, administrators would look before a couple years ago, and they would say, if it's on 1214, it's got to be Caza, and they could just block it. And but that didn't last long. It worked great until they came up with dynamic port hopping. Basically, with dynamic port hopping, the P2P application, it really can't be identified or controlled by the port number. But basically what you have is a lot of smart people on the P2P side, and you have a lot of smart people on the network monitoring side, so they're kind of like in a battle. And these smart people on the network monitoring side have come out with products where they're able to classify P2P applications at their application signature level. So if you're familiar with that 7-layer OSI reference model, instead of looking like in layer 4, transport layer, to try to look at port numbers and identify it that way, they're going up, and each application has some kind of signature that it gives, and they're digging into these packets and looking at that and saying this has got to be Caza, this has got to be Nutella, and giving you more capabilities. But these things aren't cheap. I've seen some of them $4 grand, $7 grand, 20 grand, 49,000, and on. So depends on how fast the thing is, how much it can do. So it's not cheap. But one thing that's interesting, even though it's not cheap, is you can't just throw bandwidth at this problem. They've had ISPs and stuff throw more bandwidth at this, and almost immediately within a day, the peer-to-peer are just eating up every bandwidth data. So you can't hit it with bandwidth. It's got to be done another way. HTTP tunneling is another thing, where it's actually tunneling through port 80, so it looks like regular web traffic. And there's actually companies out there, httptunnel.com, will let you, has a whole thing where you can if they're blocking, have a firewall, lets you go to your home computer, send it off to their server, it comes back in this way and looks like web traffic. It's pretty, so you got a lot of smart people that are out there doing all kinds of things to try to beat this thing. There's the OSI reference model. I won't go into that in detail. Now, P2P at universities is a big problem for administrators. Bandwidth management is a huge issue. There's security issues. These peer-to-peer P2P environments are just ripe with, it's a perfect world for hackers, viruses. Users, this stuff is so easy to use. All you have to do is, if you can breathe and move a mouse, you can go out there within a couple minutes and be on Caza downloading just about anything you can think of. But you can also open up your computer to everybody out there. You can have your hard drive open up with your credit cards. I did some searching a while back, strictly for educational purposes, looking for credit card numbers, and I found stuff that, I mean, a person would put their name, here's my bank account, here's my Visa number. Whether it was fake, I don't know, but it looked awful real. Because, you know people do that. You know, they're trying to keep track. They have all these PIN numbers. They keep it on a file. They download Caza. They open up their whole hard drive. They don't know that they're sharing it with the world. There's also copyright issues with Valerie's going to talk about. There's child porn on these things. The government study recently said that these things are loaded with child porn. So this is a whole nother world out there in cyberspace. Interestingly, at the university, these things are universities are bandwidth rich. It's perfect for a peer-to-peer. A lot of these students are leaving their computers online 24/7, and it's just people know about it. They go to university pipelines, getting Britney Spears. Everything's coming up out of their pipes. Students love music, especially if it's free. Interestingly, a bigger problem at the university is uploading and not downloading. Apparently, college students love to share their music also. The University of Washington did a study. I'm going to go through real quick. They did a 9-day trace back in 2002. This is a 60,000 student campus with students, faculty, staff. During this time, they had 500 million transactions they logged, over 20 terabytes of HTTP data. And a terabyte is like a whole lot of information. I had to actually look these up because these numbers, you hear these things, so I actually looked at what is a terabyte. It's actually 1,000 gigabytes, and a gigabyte's a lot of information. So. But during this time, the web traffic was 14% of the TCP that they tracked. P2P was 43%. Uploads significantly exceed downloads. This is the same for ISPs. ISPs, they sell their the way they sell their product is they used to give you you were limited more on your downloads than your uploads. Now they find out that they're giving people unlimited access for a month, paying $32 or something, or $40, but all their upload is taking up all the bandwidth. So it's totally disrupting what ISPs are doing too. They compared it to what they did in '99. HTML was down 43%, and GIF and JPEG down 59%. But movies, AVI, MPG had increased 400%, and MP3 had increased 300%. Some additional stats: the medium object of a web object was 2 kilobytes, but of a P2P it was approximately 4 megabytes, a 1,000-fold increase. 5% of the Caza objects were over 100 megabytes, and the requests for the top 300 Caza objects accounted for 5.64 terabytes of traffic. That was the actual upload of the music and also people coming in and asking for it, all that chatter and stuff. Caza is really big on movies. 80% of Caza was video, 14% audio. Nutella was more even, as you can see by the stats. The top 200% of Caza peers, only 4% do 50% of the traffic. 20% of the total HTTP bytes downloaded. The top 170 Caza peers were responsible for 50% of all HTTP outbound traffic. And I'll skip down to a few of these. Average web client used 41.9 megabytes of bandwidth. The average Caza user was 3.6 gigabytes. It's 90 times the web client. And they conjectured that hypothetically, if they added another 450 Caza peers, that would equal to doubling their entire campus web client population. And that just shows, this is a thing from the same study, just shows outbound of Caza was up to 13.6 terabytes just during those 90 days. Cornell had a similar experience in a study they did in 2002. Top 20 bandwidth users used more than the bottom 5,000 users. And that was like, as you can see, the gigabyte difference between that. The single heaviest user used the same amount of bandwidth as 2,800 typical users. And Cornell's network people thought that if everyone on campus turned off only the outbound Caza traffic sharing, they would have approximately 50% more bandwidth for other internet traffic. Now after all this, as I was reading, I thought I came up with my own definition, at least of some peer-to-peer. since we started with the definition, I started calling it parasite to parasite. Now, the definition of a parasite is it's a noun. It's an organism living in or on another living organism and deriving its nutriment, partly or wholly from it. And in this case, we're talking about bandwidth and free music. And it usually exhibits some special adaptation. In this case, port hopping, firewall breaching, HTTP tunneling, and often causing death or damage to its host. Very greatly slowed down networks that other users can't use, and a lot of lack of sleep for network administrators. And so with that, I'm going to turn it over to Valerie.
Do I need to answer that? Okay, so say yes. Well, Mike has given what I think is a fascinating talk on the technology and the economic drains to universities and obviously the computer administrators. I'm going to talk more about the law, and forgive me if some of you know a lot of copyright law, because I'm going to start out with the basics for those of you who don't know as much about copyright law. I'm going to talk about what it is, what possible defenses there are for copyright infringement. There's federal and state statutes. There is some very interesting case law, not the least of which is Napster, which Mike has already referred to. And I'm also going to look at some future trends in litigation and what's happening out there now, basically. Copyright law is actually based in there's a clause in the Constitution itself that is the basis for copyright law as well as for patent law. And I've listed it here. It's to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. The battle, and I guess the difficulty with copyright law is balancing. And you have to balance basically the incentives for people to create by giving them copyright law so that they can financially benefit from their works. First is public access to these works so that they can go out and use these works and develop new works based on the old works and create something new. And that's a constant struggle in any of these copyright cases, is kind of defining what that balance should be. Under the federal statutes, of which I've cited to 17 United States Code 102, basically copyright law is heavily in the statutes in the federal law. So a lot of these cases are going to cite to statutes. And the statutes not only define the copyright law, but tell you what kind of relief is available for you in court. And obviously there's going to be a lot of cites anyways in these opinions to the statutes. Under the law, the sound recordings are clearly eligible for copyright protection. Oftentimes, we hear a lot of rhetoric about how the artists are being hurt by music being downloaded illegally. But the reality actually is that the parties in this litigation are usually the recording studios. In order to get a contract, especially for a struggling young artist, you have to sign away your copyright. So we're really not talking as much about the individual creators of music. We're talking really about the recording studios who have been assigned this copyright. And they are the ones that are heavily involved in the litigation. They have the money to pursue these suits. And oftentimes the artists themselves are ambivalent. We have a lot of kind of new artists who are out there who actually like using legitimate file sharing technologies because it's a way for them to disseminate their music. They don't have to go through the recording studios anymore. So we're seeing like a really different whole new models of distributing music that the recording industry is finding very threatening because they no longer have the same role that they used to distribute music to the masses. So that's kind of the background of what's happening with the litigation. The two rights that are exclusive rights for copyright owners that are implicated in these cases are the right of reproduction, which is involved whenever you download a song, and the right of distribution, which is when a student or someone else uploads a song to one of these peer-to-peer technologies. And that you'll see throughout the case law. There's different types of infringement. It's important to know that it really doesn't matter what type of infringement you are found liable for, because the penalties are the same. It's extremely harsh. It's $150,000 per song under the statute. And regardless of whether you yourself have directly infringed as being someone who downloads one of these songs, or whether you are found to be contributorily responsible for the infringement, you're still liable for those damages. And so that's kind of how the battle is shaping up. Now, the online service providers are really in a tough spot, because according to the doctrine of contributory infringement, it's a fairly low standard for a recording studio to meet when they're litigating. Basically, let me just read this to you. The definition is: with knowledge of infringing activity, the defendant induces, causes, or materially contributes to infringing conduct of another. And that was stated in the A&M Records versus Napster case. Also, another doctrine that's often used in the litigation is something called vicarious liability, which basically says that it's usually used for employer and employee relations, but in this case, the OSP, or the online service provider, has the ability to control subordinates and derive some kind of financial benefit from the infringement. And that sometimes, again, is of concern. And oftentimes these suits really involve contributory infringement and vicarious liability. The direct infringement is less of an issue, actually, because if you look at it, who has the money? It's not usually the students who are downloading the music that have deep pockets. It's going to be the online service provider, whether they're a commercial entity or whether they're an educational institution, who has the deep pockets and who is unfortunately being used often as a conduit for this kind of infringement. So it puts universities and it puts online service providers in a very awkward position. And I'll talk about some of these conflicts that are ongoing. There is a defense to fair use. It's a defense to copyright liability, but it's an affirmative defense, which means you have to go out and prove it. And so the burden is on you, the infringer, to actually prove that you qualify for a fair use exception. Under fair use, there's 4 factors that you look at. You look at the purpose and the character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect of the use upon the potential market for the work or the value of the work. Now, in the Napster case, this was argued. Napster said, well, the direct infringers, i.e. the students or whoever is using our services, qualify for fair use, and therefore we're not liable because this defense protects them, and there can't be any contributory infringement if they're not liable for copyright infringement. So they argued this, and they were, unfortunately, in their case, quite unsuccessful in persuading the court. Basically, the court found that all 4 favors weighed heavily in favor of the recording industry and the studios. They looked at the purpose and the character, and they found that it was essentially commercial because fundamentally students were downloading this music to save money because they didn't want to pay for the actual legitimate copy that was out there. The nature of the copyrighted work, that's usually an analysis of how creative is the work. And music is creative, there's no question. It's not a bunch of facts or information. It's a very creative work, and therefore they found that was in favor also of the recording studios. The amount of substantiality, clearly we're talking about an entire song. We're not talking about just a piece of a song here. So that again weighed in favor of the recording studios. And lastly, the effect of the use upon the potential market of the work. This is almost always going to be in favor of the plaintiff because, any times that you can download something for free that you would otherwise have to purchase, you're going to lose on that factor. So this was really rejected in really all of the case law. The Digital Millennium Copyright Act was passed in 1998. It's a federal law, and unfortunately it's quite intricate, but you have to have some kind of understanding of it because it also is often implicated in these types of cases. It applies to online service providers, which most people agree would include universities, since they're providing bandwidth for students. Basically, you, as the online service provider, are prohibited from making available certain technologies that are developed or advertised to defeat technological measures. So this, as you can see, this is starting to sound a lot like university bandwidth that's being made available here and what is happening on this bandwidth. There's a couple of provisions that could apply to universities. One of them is on transitory digital information. That means there's no central server. It's just transitory. And then the other one is the actual safe harbor requirements, which, if they can be met, protect you from liability. The problem is it's hard for you to meet them, and if you don't fall into this act, then you're completely outside of it, so you can't use it as a defense. This is kind of a list of what responsibilities the OSP has so that they're not liable for dollars. I don't know if I mentioned this before, but they can be subject to some kind of injunctive relief, which means basically that the court says, stop this from happening, remove these files. But they're not financially liable if they can fit into this provision here that's in the federal statute. You have to have transmission initiated by someone else. It has to be an automatic process. Can't select recipients of material, no copies made. And it's transmitted through the system without any modification. In other words, you are merely a conduit for information or for files. You're not actually actively participating in any kind of infringement. And then there's a few other provisions that you have to meet in order to fall within the safe harbor, which these are actually not so bad. The hard part is fulfilling all the conditions in A. In order to meet that. And so far there hasn't been any litigation yet for universities on to what degree these provisions apply, but it seems pretty clear to people that if a university is sued, that they're going to have to rely to some degree on using this as a defense, and that hopefully they will fall within the safe harbor so they don't have to worry about financial liability. And again, it's $150,000 per song, so we're talking about what could be a really substantial amount of money if the recording students decide that that's the path they want to take. There has been a lot of lobbying by the recording industry. There's a lot of money to be made, and the new technologies are very threatening to the old business model of the recording studios. And not surprisingly, Howard Bernstein, who is a Democrat in California, has submitted a bill to allow companies to take self-help measures to prevent peer-to-peer technologies being used. In other words, the recording studios and the RIAA, which is the Recording Industry of America, Association of America, can actually develop technologies that really go out and attack other people's computer systems and delete files. And it's actually quite disturbing, I think. It hasn't passed. The bill is still pending, I think, in a committee right now. It's called the Peer-to-Peer Privacy Prevention Act, which to me has nothing to do with actually the substance of the bill. But it has some disturbing implications for OSPs, I think. And the idea that someone from outside can actually use some of this technology to disrupt computers' systems is a scary thought for me. And it's probably a little scary for computer administrators as well. So we'll have to keep an eye on that and see what happens. Then you get even more extreme perspectives. Orrin Hatch actually is a songwriter, and he receives royalties, which is not something I knew before I was actually researching this area. But recently, a couple days ago, in fact, he actually was quoted as saying, "There's no excuse for anyone violating copyright laws. If there's no effective, non-intrusive way to stop pirates, I'm all for destroying their machines." Which brings to mind all kinds of images, and I thought this one was kind of an appropriate image for his quote, but we don't really know what he means. And it's obviously these attitudes are a bit concerning, I think, for everybody who's kind of monitoring the copyright law. There's also a lot going on the state level, which really has not been publicized at all, which I find surprising because what they're doing is RIAA and the motion picture industry is also going in and lobbying heavily for state legislators to pass laws. These laws are actually criminal laws, and they're usually amendments to existing criminal laws, which utilize extremely harsh measures to punish direct infringers. In this case, this representative is quoted as saying, if you prosecute someone and put them in jail for 3 years, I think this would act as a deterrent. Yeah, that's probably true, but I don't know if we want to start jailing students, who are guilty of infringing copyrights. And in fact, they've been called the super DMCA because of the harshness of the penalties involved. They're very broad. They define a communications provider as really almost any entity that provides any kind of a service. in any way as a conduit of information. It's treated as a felony with fines and jail time, and it's already passed in several states: Delaware, Illinois, Michigan, Oregon, Pennsylvania, Wyoming. It's pending in several other states. Recently, the legislation was vetoed in Colorado by the governor, who stated simply that it was overbroad and it just had too much application, and he wanted a more narrow law, and so that was vetoed. But overall, they've been very successful because, again, they are giving a lot of money. Meanwhile, the music traders have kind of had their own response to all of this lobbying going on, and as you can see, they have very definitely mocking what's happening. I think you probably know that Napster's symbol is a cat, so they're poking fun at it as well, but that's been the extent of their lobbying efforts, unfortunately. So let's talk a little bit about the case law. The first big case in this area is Sony versus Universal Studios. This involved the manufacture and sale of the first VCRs, basically. They called them Betamax VCRs. And Universal Studios was actually the copyright owner of a number of television shows. And so they went out and they sued and said that they were liable, that Sony was liable for copyright infringement because they were out there providing these VCRs so that people could go and tape the programs from the television. Now, this is something that I take for granted, that we can go and do that, but at the time it was really the first case in this area, and so it really wasn't clear what the law was going to be, and how were they going to handle technology that copied material that was protected by copyright law. So anyways, the court, and this went to the Supreme Court, held that the test for contributory infringement was that the sale of copying equipment was not contributorily infringing if the product was used for legitimate, unobjectionable purposes, and that copying technology should be capable of substantial non-infringing uses. And so basically what they said is, if there's a legitimate reason to use these VCRs, and this technology has many other applications beyond just copying shows, then it basically passes this test, and as long as it has that capability for substantial non-infringing uses, then it's not considered contributorily infringing. Now, you have to keep in mind that the context, again, is that people are at home using the VCRs kind of for their personal use. They're not selling these presumably they're not going to be selling these programs. And there also was a statute at the time, which is still in the books, called the Audio Home Recording Act, which specifically authorized people to use to record shows from televisions, and said that it was not a violation of copyright law if it was for just personal use. So it's not clear exactly to what extent this case has now controlling law, and how applicable is it with the new technologies we have. The statute makes no mention, obviously, of digital copying, and it was because obviously the statute is fairly old and did not anticipate this kind of technology. But it seems clear that the intent behind the statute was to allow people to copy for personal use. And that's, I think, a lot of what's kind of driving students and people that are being polled all the time about these technologies. They say, on the one hand, it's infringement, but on the other hand, there's nothing wrong with it. And I think there's kind of an ambivalence, because a lot of them think, well, it's for my personal use, I'm just sampling these songs, I might still go out and buy something. And I think that's what the polls are starting to reflect, is somehow I think they are kind of analogizing it unconsciously almost to a VCR or something else that is a legitimate technology that is being used. And the courts just, well, up to, at least the Napster court just was not going to buy that at all. But I'll kind of explain how they analyze the case. A&M Records versus Napster is the big Napster case. It's extremely complicated because it started out in the District Court of Northern California, but it went up to the Court of Appeals in Ninth Circuit, which is the applicable Court of Appeals. It was sent back to the District Court. It went back to the Ninth Circuit. So we're talking about a number of cases, really. We're not just talking about one case specifically. So it gets fairly complicated. Interestingly, something I didn't know when I went through my reading is that USC, Yale, and Indiana were actually in the initial suit. They were dropped from it because they decided to ban Napster from their campus. They claimed it had nothing to do with the suit, but I'm always a little skeptical when I hear that, especially when there's a large lawsuit involved. So they dropped out very fast and they were no longer in the lawsuit. I think the important facts for this case is that the digital technology that Mike's talked about for downloading music files, it was a centralized service. You would use it to make these MP3 files. Napster assisted you with searching for files and transferring files, and according to the court, these music files were residing on a centralized server network. Now, Mike pointed out that this is actually, Napster is some kind of a hybrid peer-to-peer. It's not clear how much the court really understood the technology behind it, but what was clear is that they kept repeating throughout their opinions that it was centralized, that Napster had taken a very active role in promoting the service and registering people for the service, and that therefore, because they had kind of undertaken this responsibility to bring people into the service and to encourage them to use the service, that there was an issue of what kind of control they were exerting on the service and on people in general who were using the service. The court looked at Sony, which they had to, really that was the only applicable case, and it was a Supreme Court case, and they said Napster had actual knowledge of specific infringing activity, and that also another important fact was that they could redesign their system to prevent illegal copying. This is a finding of the court. I think, as it turns out, it's not clear that they really could redesign the system to completely prevent illegal copying, but they did try, actually. And I think what's important, too, is this knowledge requirement was not relevant in the Sony case. The court actually said that knowledge was not relevant. And yet here in this case, which is a Ninth Circuit case, essentially, they were saying that actual knowledge of that infringement was important, and that made them liable in some way for this infringement, and it made them liable for basically being contributorily infringing, and also they found that they were vicariously liable also, which meant essentially that they were subject to the same penalties as a direct infringer. They also found that Napster was not protected by any kind of safe harbor in the Digital Millennium Act. Easily they could have found I think they could have easily went the other way on that. It wasn't clear if they were considered an online service provider from the statute. The court basically said because of their knowledge that somehow they were not eligible for any kind of safe harbor requirement, or they couldn't meet the safe harbor protection, and therefore they were kind of outside the scope of the Digital Millennium Copyright Act, which is interesting because I have a feeling that at some point that will become part of the analysis. I don't know, though, because, again, the court has said that this just isn't governed by the Digital Millennium Copyright Act. And lastly, they rejected the fair use defense, which I already went through, because it was, as I said before, the four factors weighed very heavily in favor of the recording studios and against the users. So that wasn't an available defense for Napster. There were a lot of different holdings that came out of the Ninth Circuit and then the district court. But basically, it started out, they said that Napster had to remove user files from the system's music index if it had reasonable knowledge that the file contained the plaintiff's copyrighted works. So they were, and this actually had a notice requirement, so that at least the plaintiff was required to tell them what files were infringing, and then they were supposed to use their search index and go in and remove those files. Later, though, what happened was they were not able to remove all these files. The district court judge in particular, I think it's safe to say, was a little annoyed about this, about the fact that they weren't removing all the infringing files, and they also continued litigating and appealing all of her decisions. So after it went to the Ninth Circuit and came back again to the district court said that not only did they have to remove infringing files they were told about, but now they had to go out and actually affirmatively search for infringing works and disable access to them on their own. In essence, they had a duty to police their own system. So they were responsible for looking for possibly infringing files and destroying them. And what they did actually is they came up with a whole new filtering mechanism that they were using to try to destroy these files. I genuinely think they were trying at this point to go ahead and remove those files, but they couldn't do it. They just could not find all of the files on their system, at which point the district court issued a shutdown order for Napster and said that all infringing files had to be eliminated in order for them to go back into business. The judge, Judge Patel, said the standard is to get it down to 0 infringing files, which I suspect is a little unrealistic and is a very difficult standard for any kind of OSP or any kind of company to meet in this case. since the whole purpose of this service was to exchange files. So how did the peer-to-peer file sharing companies react to this decision? Well, I think they did what most technology companies do, and they innovated. They created new technologies, and they also responded to the case by decentralizing. They realized that what was very crucial to the Napster case was the fact that the system was so centralized, that Napster had the ability to control the users and register them and had so much control through this central server. So they went and they decentralized, and they created some of these new peer-to-peer technologies that Mike has talked about that use supernodes and that are completely decentralized systems, so that they didn't have to go back into court and say, you know, we know under Napster centralized system equals infringement. Here they're trying at least to go, or we can all question their motives, but they were obviously reacting in the court opinion and trying to do something different here. The other thing that they did was they decentralized their company, and Caza is a prime example of this. They're very clever. They know what they're doing. What they did is they made it virtually impossible to be located so they could be sued. Jurisdiction is a nightmare because of basically they took pieces of the company and put it in all of these obscure places. They have servers in Denmark. The software operations is now somewhere in Estonia and off the coast of Britain. Domain names registered in Australia to Charmin, which you might have heard of. And Charmin itself was incorporated in this tax haven, some random Pacific island nation. So basically, they actually have been sued, but nobody can find anyone who's responsible. And they suspect that Charmin itself is the entity controlling it, and it's someone in Australia. What?
I would call it a hole in a pocket.
Yeah.
Deep pocket.
Well, so anyways, the recording industry didn't give up, though. Here, MGM decided they were going to go ahead and sue Caza anyways. And they also sued Grokster, or was it, I never know how to pronounce this, Grokster, I'm just going to say Grokster. And then another company called Morpheus as well, or actually it's a company that used Morpheus called Streamcast, I'm sorry. But, so what ended up happening was Caza said, you don't have any jurisdiction over us, so they just had nothing to do with the lawsuit. They didn't show up in court. So I don't know what's going to happen to them, because basically the court says our opinion doesn't apply to Caza because they're nowhere to be found and they weren't even coming to court in the first place. Meanwhile, Grokster and this other company were at least trying to defend themselves in court. The court, again, decided to go through this contributory liability analysis, which we already talked about. But basically, in order to be contributorily liable, you have to have knowledge, and you have to induce, cause, or materially contribute to that infringing conduct. So what is this knowledge requirement? Remember, Sony says this knowledge requirement is actually a very specific kind of knowledge requirement, and then it's really not that relevant anyways. Napster, on the other hand, the Napster case basically says, well, all you need to know is that there's some kind of general knowledge that infringement is going on, and this court had a whole different take on it and decided that general knowledge of infringement was not enough, that you actually had to have specific knowledge at the time of the infringement and then fail to act upon that information. But then, interestingly, they went ahead and said, in addition, it doesn't matter if you get this notice if you can't do anything about it at the time. So I think that's something that's going to continue to be litigated in the courts, because clearly we've got some very different opinions here about what kind of knowledge is required. Now, this is a district court case, and the other case was a Ninth Circuit case, so it's being appealed, and I don't know what's going to happen during the appeal, but
Is this also in the Ninth Circuit? I mean, underneath it?
yes, it is. It is. So there's no question that it's going to end up in the Ninth Circuit, and it'll be interesting to see what they do with this decision. Now, this is in a different district court, but this is a central district as opposed to the northern district, and clearly the judge here had a very different take on Sony and what it meant. But ultimately, it'll be interesting to see what the Ninth Circuit decides. This case actually came out in April, so it's very new, and there's been a lot written about it, and the recording industries are scared to death about this case, because basically what they did is they looked at these systems. They said it was decentralized, it was not like Napster, and ultimately they said because they're so decentralized and they're more pure peer-to-peer, the companies themselves were not providing any kind of site or facilities for direct infringement, and that's really what they were requiring, was site or facilities, in order for you to meet this contributory infringement test, basically. So And then they looked at vicarious liability and said, there's an obligation to police the site, but only if you have the right and the ability to supervise the infringing activity. And they decided that they didn't have that ability because they weren't centralized. Napster, they said, was an integrated system, and it was designed and operated by Napster, but Streamcast and Rockster merely distributed software, and that was not enough for them to exert any kind of control or supervision of the infringing action. So really the technology was the kind of the crucial distinction, the type of technology that was being used, according to the court. The recording industry was very surprised by this decision, and of course they are appealing it, but they've also moved on. And I'm going to really go through this quickly since we're almost out of time. But the latest suit actually has been RIAA versus Verizon. And this is a very different kind of suit. What they're trying to do now is subpoena online service providers for identities of direct infringers, which raises all kinds of questions. And the problem is that the subpoena power, which is allowed for, is a very general kind of, it's a very easy standard to meet because they don't have to prove anything. They don't even have to allege that a crime is being committed. They can just go to the court clerk and they automatically will get a subpoena. And so Verizon, the online service provider, did not want to provide the names of these infringers, alleged infringers, because it has so many implications for privacy of the users. So this case actually basically is a very negative case, I think, for computer administrators, because there's that potential that someone could subpoena university and ask for identities of people who are infringing. So that's kind of out there, and in fact that was just appealed, and the appeal was rejected, so it stands, and they had to give over the names of 4 people who were allegedly infringing. Meanwhile, they're also suing students at universities. In fact, there were several cases in which students were distributing programs, intranet file sharing as opposed to internet. So it was only sharing files within, I guess, the university server or the university itself. And they settled those recently for $12,000 to $15,000 per student. But obviously they were making an example of the students. The students are upset. The universities are extremely upset about this. So we don't know what's going to happen with that. Universities kind of responded, I think, in a kind of a typical manner. They're feeling ambivalent. There's academic freedom issues and privacy issues, but then there's also the bandwidth costs and liability. They're actually creating detailed policies because they really have to have some policy that says you can't infringe, and we have the right to terminate your account if you do. And they also formed a committee, which I guess is another typical response in education, higher education, and that's actually chaired by the president of RIAA, and it's also co-chaired by the university president of Penn State, who his name is Graham Spanier, I think. As this is going on, we also have this new service called iTunes, which is for Mac users, and it's a legitimate service. Licenses have been paid, so it's not illegal file sharing, it's legal, and it's actually been quite successful. It's only 99 cents to download a song. iTunes sold 1 million songs during its first month of operations. At the same time, as Mike pointed out, Caza is more popular than ever, and it's just phenomenal the amount of downloading of this program that's going on. So we're left with a lot of tough questions. You know, what level of knowledge is required of the service provider for them to be liable for infringement? How is the court going to handle these new technologies that are emerging that are, you know, hybrid of centralized and decentralized systems? How is the Digital Millennium Copyright Act going to be applied to these cases? Again, so far it's been outside of the Digital Millennium Copyright Act, but it could easily become, all the court needs to say is that it applies, and then we're going to have a whole new set of questions. And what's going to happen with the universities? Are they going to have to start releasing names of student infringers if they're subpoenaed? It's not looking good. And another case sued Bertelsmann, which is a big entertainment company actually, for investing money in Napster. They actually were trying to turn it into a legitimate business, and they were trying to promote the legal file sharing services, but they did invest, and now they're being sued. Meanwhile, Graham Spanier has proposed a mandatory fee for universities, which really is not financially really that desirable I think from a university perspective, but would make the recording industry much more happy, because then it would be licensing music as opposed to them downloading illegal music. And lastly, a case that really I have no idea what's happened with it because there's almost no publicity anywhere about this case, is the international version of the RIAA sued the United Kingdom universities for contributory infringement. And so far, haven't heard anything about it, haven't seen any newspaper articles about it. I'm guessing it's going to be settled, but you know, that's another disturbing trend that's kind of out there. And if they do end up settling, that could have some disturbing implications for us as well. Thank you so much for all your attention. I know that we kind of took you through to the very end here. If you have questions, Mike and I would be happy to answer them. Or if you just want to kind of digest all this information, we understand it was probably about a terabyte worth. So, thank you. Yes?
I have a really quick one. Did you say the Verizon case was a Court of Appeals case or a district court case from the D.C. Circuit?
It was a district court case, and the district court held that they did have to turn over the names, but then it was appealed to the Court of Appeals, who basically said that upheld the decision. So they've already turned over the names of these 4 alleged infringers, and I think there's going to be a lot more of these types of subpoenas out there as a result. Yes?
With the Verizon case, did they have awareness of, by an application signature, of that before people actually were taking music files, or just the fact that they were uploading and downloading lots of information?
That's a good question. I don't know. I don't even know if the court mentioned it as relevant in their opinion. I'd have to go back and look at it.
Yeah, I don't know how they identified. I don't know the technology.
We don't know if it's new technology they were using or how they figured out that these, maybe it was just based on the bandwidth.
But it wouldn't be a problem for somebody to run a network to see where it's all coming from or where it's going to, even if it's tunnel. You know what I mean? At a certain point, a big upload or download, if it looks like a duck or walks like a duck, it's probably P2P.
Right, but
I don't know exactly how they said this person. I know the universities know exactly what computer it's going to or coming from. That's not a problem for administrators.
But the RIAA administrators, IT administrators can also figure this out.
I'm guessing that the RIAA identified IP addresses and subpoenaed Verizon as to who was registered for those IP.
But they knew that those IP addresses were transferring music files.
I think RIAA something else.
Because they could
I'm only guessing,
Yeah.
that's the only thing that makes sense.
Because an RIA person could
Because
download.
Verizon is not going to voluntarily identify
They
that.
did. They fought
and you could
this
do
to the
that
bitter
because
end.
at the point you pull up a Caza or BearShare, one of the Nutellas, and you actually initiate the actual file transfer, you can know if you got the IP address the person is coming from or going to. So that should be, I don't think that's a problem.
Your question is that.
Yes.
I think what concerns me most is early in your presentation, one of the slides talks about DMCA and super DMCA in several states where that type of legislation has been passed, broad language, actually potentially criminalizes the implementation of firewall technology for security purposes, since it does hinder or prevent reasonable measures from outside agencies to detect copyright infringement. And I know specifically in the state of Pennsylvania, that's a very large concern for network administrators who will be held responsible for deploying such technologies.
And taking that a step further.
That's what concerns me, while on the flip side, we've got the federal government saying that you have to secure your networks to keep people from using them as launching pads. So you've got this dichotomy.
There's so many pressures now coming from so many directions too, and also national security concerns, which I have no idea what those are, but the University of Houston has actually disabled or is trying to disable peer-to-peer technologies and claiming that they are somehow required because of the homeland security issues. I don't know exactly why, how that's gotten brought into it, but it is. So you're really caught in a tough position.
Network in 2004, you'll.
Yeah.
2003 and 2007.
Just to tag along with what she said, the technology that we're using now for IP4 and using NAT boxes to translate, that could also be seen as blocking their ability to tell who it is.
Reasonable measures. What are reasonable measures?
Yeah, it's a lot of tough questions, and I hope that nobody has to litigate those in court. So.
They will.
But they probably will. Yes.
I understand there are some universities that actually have a limit on the amount of bandwidth that can go through their lines at any one time and will cut it off, and or they have a monthly download limit or something. Do you know much about those, how successful they are?
Yeah, there's part of it is technology, part of it's political. If they do kind of shut down all peer-to-peer, it might get a student uprising. They can do things with this, they call it packet shaping or whatever. They can when they could identify the P2P, they could say, this is all called entertainment and it's getting a lower priority. Our applications that have to do with legitimate educational things are going to get a higher priority. We're going to shove this off. It's either can go through at a different time or it's just not going to get the priority. We won't shut it off totally. And I have seen there's different versions of what's going on, whether they want to limit or something, or see who is the main people that are using up bandwidth and then contact them directly. They can shut them off. Say you're going to lose, if you keep this up as your first warning, then you're not going to be on the net for the next year unless you go to Earthlink and get out of the university.
Was it one of those pay services you were referring to earlier that could cost up to $45,000?
Yeah, actually I've seen a wide range of things, but it looks like the newer, the ones that they're more expensive ones, they got to dig through that layer 7 and try to figure out that.
Computer administrators, I would say, are definitely erring on the side of being cautious because you just don't know what the liability is and you don't want to be the test case. They've even had, what happens is the recording studios will send over, they'll contact them and tell them that all of these files are infringing, and then they're obligated to, at that point, or they feel obligated at that point to track down the users and either disable their access in some way. It's even happening with professors, which is disturbing. There was actually a professor whose name was the same name as a music group, and they got confused and said that there was this infringing file in his account, and it was one file we're talking about. He was losing access, to his account. It's definitely going to be an increasing problem, I think.
And it's not only even for administrators; it's the students that are trying to do legitimate things, and they're in contact. Why is it so slow? You know what I mean? And it happened here at Duke, where Duke had filters on to stop Caza and stuff, and it worked. It brought it way down. They could stop the P2P, and then in September 2002, I think September 23rd, Caza came out with their newest dynamic port hopping, and even though they had the filters in place, it just shot up. They have it on their website. It just shot right back up. And it happens like within a day or two. I mean, you can throw all the bandwidth you want at it. You can't add more bandwidth. That's not going to be the answer.
Yeah.
Because see, the
people are too smart.
That's as people in Australia or someplace, they know that the universities here are going to have a high bandwidth, and so they'll come here to get it. Yes.
I just want to say one product out there that does that type of packet shaping is Packeteer, which is what we're using at UOP. And that seems to work pretty well because it does go to layer 7.
Now, is it doing is it getting to the layer 7?
Yes,
it's doing
layer
the
7.
Stuff. So it actually can identify.
And it works very well. There's a lot to it. It can be tweaked.
Packeteer is one of the big names.
And it's about $7 to $15,000 depending on how big of a system, how much throughput you need. Packeteer.
Yeah, there's a company called Sandvine that did a recent paper that's always cited on it. There's probably like 6, 7, 8, 9, 10 big names out there that you always see. Packeteer is one. Net Reality, I think.
I think if you did
you don't want any trouble.
Did a Google on
you
packet
won't have any
shaping,
trouble.
probably.
Exactly.
Thank you so much for your attention.